Committee will call this meeting to order. Roll call, please.
Representative Allemand.
Present.
Representative Allred.
Here.
Representative Banks.
Here.
Representative Conrad.
Here.
Representative Crago.
Here.
Representative Davis.
Here.
Representative Slagle.
Present.
Representative Winter.
Here.
Chairman Eklund.
Here. So we're going to change the order of the bills. We'll be doing the Hydes bill first, and then we'll jump into the temporary water use agreement bill. And then as time permits, we'll do the others. So would the Director of Brand's office come on up and maybe give us a little background as to why this bill was brought and what it does and why it's important?
Morning, Mr. Chairman, Committee. Steve True, Director at the Wyoming Livestock Board. This is a bill that your joint committee worked pretty hard during the interim with us. The nexus of it or genesis of it was we've always inspected all the hides and the plants have supplied hides. Back in my time as inspector, I'd look at palletfuls of hide once a month at the slaughter plants. But as times have changed and the drop value, which is the credit for hides, offal, variety meats, that sort of thing, off of a carcass, as those have changed and hides have become probably the lightest player in that market rather than the biggest, there's been no market for hides. So our slaughter plants have not had a place to go with them. They've been disposing of them in many cases, which was unlawful by previous statute. We weren't inspecting them because there were no hides to inspect, which was basically unlawful by previous statute. So your committee repealed part of that and changed it to where now we will only inspect hides if they're sold to a hide buyer and they move across the state line. Our pre-slaughter proof of ownership inspection will be our last responsibility prior to slaughter. You also repealed a statute, 1123-104, which dealt with home slaughter, talking about the different ways to approach that. If a rancher slaughtered a beef and the neighbor claimed that was one of his, ways we could approach that. We can still investigate that just as on a larceny basis to start that, so we can deal with that without the misdemeanor actions that were previous in that statute. So, Mr. Chairman, that's kind of the nexus or the history of this bill and how it came here, and I'd be happy to stand for any questions.
Committee questions? Okay, one thing I'd like to know is, so if things change and the market for leather becomes more significant than it is right now, which it probably will happen, it just seems to, it's either zero or a pretty good market is what hides amount to. Will we need to change anything in law, or are we good with just that one brand inspection before slaughter?
Mr. Chairman, market-wise, hides have been on a downtrend since 2014. If they were to come back, I should say they've been basically replaced by synthetics in that manufacturing realm. If they were to come back, there are no rendering plants, no suppliers in the state of Wyoming, so they're going to cross the state line to a hide buyer, and we would be inspecting them at that time, would be my guess.
All right, but that remains in place.
That's still in there, yeah. So
All right.
there's also a little bit in there if a slaughter plant sells some hides privately about some paperwork they need to keep and a time frame for that. If somebody slaughters a pretty longhorn hide or something that they want to keep or sell, there's a bill of sale process for that in the new statutes as well.
Okay. It looks like we have no questions. Thank you, sir. Any comment, public comment? No one online? Okay, committee, what's your pleasure? Been moved by, I'm not sure, Bill Alleman, Representative Alleman, seconded by who? Slagle. Any changes anyone can think of on this bill? Okay, I'll close discussion and I think we're ready to vote.
Representative Allemand.
Aye.
Representative Allred.
Aye.
Representative Banks.
Aye.
Representative Conrad.
Aye.
Representative Crago.
Aye.
Representative Davis.
Aye.
Representative Slagle,
Aye.
Representative Winter,
Aye.
Chairman Eklund,
Aye.
9-0, you pass.
Okay, the next bill for our consideration is Senate File 65, temporary water use agreement amendments, and I suspect this one might take a little longer. So could we have state engineer and our experts in water come on up here, and I'd like for you to explain the bill and a little of the history as to why we even have it. Go ahead and start when you're ready, gentlemen.
Good morning, Mr. Chairman, members of the committee. My name is Brandon Gebhardt. I'm the state engineer.
And Mr. Chairman, Chris Brown of the Wyoming Attorney General's Office.
Mr. Chairman, I will explain kind of the history of this and why this came about, and then get into the bill and what it's proposing to change in the existing statutes. But this, we started hearing from folks in particularly the Green River portion of our state that dealing with Colorado River, concerns of a potential curtailment if that were to occur, and folks trying to bolster their water portfolios, specifically the junior right holders in the system, trying to protect their future. And so some of the things that, as they were going out and trying to help bolster their water supplies, they were getting, working with folks that were a little insecure about what the statute said. And so the reason that they wanted to investigate this was to provide some additional sureties to the folks they're dealing with senior water rights, if that's the avenue they're taking. And so this was discussed in Select Water over a couple of meetings. Following Select Water, both Chris and I were invited to participate in a task force to craft the language that eventually made it into this amendment to the bills. And so that was really the emphasis of what it was. Like I said, it was largely ended up being not a lot of policy change, but more of a clarification to some archaic language in the statute. And so I can try to walk through the bill a little bit. Chris, and I jump in if there's anything that you would like to add. But the first change, currently the temporary water use agreement is a 2-year agreement. Once that agreement's over, then they can reapply, we reevaluate it and either issue it or don't. So the first change is, rather than 2 years, they wanted to go to 5 years. That provides them a little more certainty on what they're agreeing to. The next change is really the change of that archaic language from what was in the original bill to essentially something that we've already been doing. Temporary beneficial purposes is the key word. That similar language was in the stricken portion, and we relied on that to execute these temporary water use agreements, but it changed some of the archaic language. It was originally intended, the immediate need when this bill was originally originated, I believe, was more for the interstate highways were being constructed. There was a lot of railroads being constructed, so they needed water for those construction projects on a temporary basis. But there was a provision in there that we relied on that would allow us to use it for other temporary beneficial purposes. So the first change is really just doing that, just taking out the list that it was originally intended for, but keeping the temporary beneficial purposes. That language is a little bit different, but it accomplishes the same thing that we were doing under the original statute. And then when we were discussing this on the Senate side, there was concerns about the ability to use these temporary agreements to provide in-stream flows. From a state engineer's perspective, we didn't believe that was the case, but the Senate did add some language to clarify that, basically belts and suspenders. So that's really what's going on in page 2. On page 3, Changing it from 2 to 5 years, there was concern that this could go on in perpetuity. So the last sentence, starting on page 3, line 1, they added that this would only, that this 2 5-year periods, and then it would have to terminate. And then the other changes were to statute 41-3-111. And what that changed is who could call these out. And I'll explain that because I think it's important. So under the original statute, if there was a temporary water use agreement and any water right, senior or junior, to either of the to or from in the temporary use agreement felt like they were injured, they can make a call to the state engineer's office. That temporary water use agreement under this statute would be shut off immediately. And then they would go out and investigate to see if the call was a futile call or a valid call. If it was futile, it would stay off, or if it was futile, it would stay off, or not stay off. If it was futile, then it would be allowed to exercise. If it was valid, then it would stay off. So the changes, and again, I think this is more for certainty to these folks entering it, but the change that was proposed in this amendment is that initial call, if it's going to be immediately shut off, is made by a senior user. The junior user can still make a call if he feels injured, but what it does is it doesn't shut it off immediately. You go out, the SEO goes out and investigates it to see if it's a valid or a futile call before it's shut off. So that's really the change in the language from with prior or subsequent in priority to which is senior. So it really just changes the timing of when that would get shut off and when the investigation would occur. So I would just reiterate that if this exchange, or not exchange, but if this agreement is harming somebody, either junior or a senior can make a call to have it investigated. If a senior makes the call, it's shut off immediately, and then the investigation starts. If a junior makes a call, the investigation occurs before the agreement is shut off. And typically, the state engineer's strategic goal is to respond to those calls within 2 days. Depending on the circumstances and the complexity of things, they may take longer, but we take it very seriously. We get out there as quickly as we can to investigate this. So the intent is that if this were to go through, a junior user is injured, then we would quickly go out and investigate. So that is really the changes and the background of it. And Chris, please feel free to offer anything.
Mr. Chairman, I might just add a little bit on top of what the state engineer said, and I want to emphasize that one thing is true under the existing statute remains true under the proposed bill, which is we don't wait for somebody to make a call to assess whether or not a temporary agreement will injure somebody. As with any potential change to water rights in Wyoming, the state engineer is tasked with doing an injury analysis up front, and that doesn't change in this bill. So when two water users get together and say, and these are invaluable tools that are employed all over the state under different kinds of circumstances. As you know, water rights are typically attached to, or they're pertinent to whatever the use is. Typically over 80%, 85% of our use is irrigated agriculture. That water is tied to the land. It goes with the land. These temporary agreements allow for these temporary arrangements under peculiar circumstances to satisfy some kind of temporary purpose. So number one, these are invaluable tools that we use all throughout the state, and without something like this, I think some of the junior appropriators in the state would feel compelled to do something more permanent, to do a permanent transfer. And that certainly isn't what we've heard in the Green River Basin from the junior appropriators. They'd like to employ these temporary tools to mitigate the potential injury that they might suffer should there be a curtailment under our Colorado River Compact. So I want to emphasize that. And whenever the state engineer's office gets a petition for any kind of exchange, whether it be for a temporary water use agreement like this statute or an exchange statute or some other sort of modification to a permit or water right, there is an injury analysis that's required on the front end. And so that remains true with the changes that are made to this bill, that the state engineer still has to analyze the situation, try to figure out whether or not what's being proposed is going to injure any other water user, be that a junior user or a senior user on the front end. And what the changes to 111 do don't change that. It simply affects the sequencing of how a potential injury is adjusted for a junior user, and it gives some additional priority to a senior user is the change there. So that's the main thing I wanted to mention, is that there still is injury analysis conducted by the state engineer's office on the front end, even under this, the amendments proposed for this bill. Happy to answer any questions, Mr. Chairman.
Committee questions? Yes. Representative Davis.
Mr. Chairman, this isn't just specific to the green, it's specific to all the drainages that leave Wyoming, is that correct?
Mr. Chairman, Representative Davis, yes, this is a statewide, affect all of the temporary use agreement statewide.
Representative Conrad.
Chairman Eklund, thank you to State Engineer Gephardt. Just a question, I guess, just a reaffirmation of our work this past year. Two questions. The first being, is there a demonstration that we've seen an influx of extensions required over 2 years, thus the promotion to 5 years? And with that, just a caveat, will it now become in 2 to 5 years, maybe will it come 7 years and 10 years? When does the temporary component stop? I mean, we went from 2 to 5, and I know, I'd appreciate your thoughts on that.
Chairman Eklund, Representative Conrad, historically, we have allowed these to renew. But the thing is, every 2 years is a new application. We reevaluate it just like it was a new application to see if there is still an injury. So we treat it anew. What this would do is it would just move that reanalysis to 5 years rather than 2. But currently, it does happen. They do reapply, they get renewed. That would just take the analysis from 2 to 5.
Follow-up, Representative Conrad.
Thank you, Chairman Eklund. And the second concern that I have is on page 2, specifically line 22. And I know we shuffle around words such as may, shall, and will. My question is, where is an instance where, or more importantly, to refresh my memory, the state engineer may, in his discretion? I'm just a little concerned, and if you can reinforce that, why we did that again, page 2, lines 22, the engineer may, in his discretion.
Mr. Chairman, Representative Conrad, I think that goes to the same context that if when we originally approved it, we didn't see any injury, so we approved it. What this would do then is just saying that if we do see an injury that we didn't know about at the time, or something new has come up, that may or may not change whether we renew it or not, I believe is all that's saying. It's not an automatic renewal. It allows the state engineer the ability to not renew something and look at all the circumstances that have come to light since the original.
Thank you.
Representative Davis.
So with this tool, if I'm following you correctly, it gives you the ability to be flexible during drought conditions, since nothing seems to be constant in Wyoming. This would give you the tool and the ability to evaluate these if a drought condition would to occur. Is that correct?
Mr. Chairman, Representative Davis, yeah, I would say that tool has not changed, whether these amendments are made or not. The tool is for multiple purposes, whether drought, wet years, whatever, but I don't know that I'm answering your question. Could that help? Thank you.
Other questions? Representative Craig.
Thank you, Mr. Chairman. So I just want to focus on page 3, and you were talking about that the junior water right could still call the SEO, call you, and say, hey, I think this transfer is affecting my rights, and you would go out and investigate it. And I guess my question is where is that language? Because we're deleting the language pertaining to the junior users out of that paragraph, or at least that's how I read it. So where's the language talking about the process that you described?
Mr. Chairman, Representative Crago, that language is scattered throughout water law. That's how we administer water. If there is a claim of injury of some sort, we will still go out and investigate. And regardless of whether it's a temporary water use agreement or there are permanent water rights that are causing that. So that is just the administration of water that's defined by statute and how we typically go. So it's inherent in all of our received claims from an injured user.
Mr. Chairman, if I could perhaps add on that, just maybe get a little bit more detail, and the state engineer is absolutely right. And just from a general standpoint, there's state statutes which allow any water right holder to make a call, just generally a call. And under our statutes, it's identified as a written request for regulation, that they're not receiving the water that they're entitled to under their right. So they can make that written request for regulation. And then the process is for the water commissioner of that particular district, to go out and assess the validity of that request. And typically, but their first step is to go to whoever's making the calling right and to assess whether or not that right is in fact not receiving water it's entitled to. And all this particular statute does is change that sequencing for the senior right, but not the junior right. Under this particular statute, what it says is if that's a senior right to whatever this temporary transfer, so you look at the priority date of whatever the water right is that's making the transfer, there's a water right senior to it. If that request comes in, you automatically shut it off before you do the investigation, okay? And for a junior right, you still fall under the regular statutes where the calling junior rights can say, I'm making a written request for regulation because I'm not being satisfied. And so then the hydrographer would go out and first make sure the junior right is not being satisfied. And if that's in fact true, then the hydrographer, the commissioner, has to make an analysis and investigation to see whether or not this temporary transfer has in fact worked some injury to this junior right that's making the call. If at the end of that process, the commissioner determines that the junior user is in fact not being injured by the temporary transfer, then there's a separate statutory process that allows the water user to appeal that decision. And because the state engineer's office handles those appeals in a very rapid fashion, because going without water can cause injury in a very rapid way, the process is the appeal goes to the division superintendent first. So the division superintendent then makes an investigation, makes a determination with regard to whether or not that transfer is injuring that appropriator. If the appropriator is dissatisfied with that decision, then there's an immediate appeal to the state engineer. State engineer conducts an independent analysis whether or not that injury is occurring. And if the appropriator still is dissatisfied with that response, then there's appeal to the district courts.
Okay. Any other questions? Okay, well, Representative Winter?
Yes, thank you, Mr. Chairman. My question is, right now is, have you folks read the testimony from the McKee family around Bags? It's this one here. It sure makes me have concerns about this bill. I just wondered if you could respond to that, or if you're not able to at this time.
Chairman Eklund, Representative Winter, I think I heard parts of their testimony, if you're talking about their testimony in the Senate Ag. And I have not read their testimony, but the one takeaway I heard from that was the concern that the temporary water use agreement could be used for an in-stream flow for fisheries. I believe that that was addressed by an amendment in the Senate that made it through the engrossed version, but I don't remember the rest of the testimony. I apologize.
Well, they mention incrementalism quite often, and that gives me cause for concern about where this thing's going. So I wondered if you could think about that, or I don't know if we need to table this for right now or what, but it's a concern for me, I know.
So, Mr. Chairman, Representative Winter, I'm not entirely sure what they mean by incrementalism. I guess in my brain, that means slippery slope. We're going to do this now, and then it's going to turn into something later. I assume that's what is meant. With regard to the changes that move it from what was previously in the statute, which was a list. There was a very identified list, and the state engineer was absolutely correct that when this statute was first passed, the main problem they were trying to solve was the construction of the interstate highways. And at the time, there was no opportunity for any kind of transfer in Wyoming of a water right except permanent transfers for preferred uses. As water law has evolved in Wyoming, there's been increased ability to make transfers. But at the time, there wasn't the ability for the contractors to get the water they needed to construct the highway. So that's how this statute first came to exist. We're going to allow these temporary transfers for that temporary purpose. And over the years, as this was changed, it went from, and maybe this is the incrementalism that they're concerned about, but it went from public highway construction and repair, and it was specifically identified as being with the State Department of Transportation. And I think the state engineer was able to communicate with Wyoming Department of Transportation, and they didn't have any concern about that being removed. And then it talks about for drilling and production operations, so oil and gas. We all know that oil and gas drilling operations require some water, but it's a temporary purpose. It's not a permanent thing. And then there's just this catch-all, or railroad roadbed construction, which is also a temporary purpose. And then it said other temporary purposes. So you had this catch-all on the end, which provided for the general restriction that this applies for temporary purposes on the back end. Whatever you're going to use this water for has to be a temporary purpose, not a permanent purpose, which is why the state engineer's office has not granted these for the benefit of irrigated agriculture, for example, because this is intended for temporary purposes. So I would submit to you that the changes, which just say temporary beneficial purposes, don't change what's already there. It already says other temporary purposes. And then I know there's been concern, and there's been numerous attempts since the early 2000s to try to include in-stream flows as a potential purpose that could be serviced by these agreements that have all failed. They've never been successful. There's an opinion from the Wyoming Attorney General in 2015 that said in-stream flows cannot be serviced by these temporary agreements. But out of an abundance of caution, I think, in belt and suspenders, as the state engineer suggested, that exclusion is now explicitly identified in here. So I guess my response to that is what this proposes, other than changing it from 2 to 5, and other than putting a cap of 10 years on that doesn't currently exist, I would submit that this doesn't include or add any other temporary purpose that wasn't already allowed for under the existing statute.
Thank you. Other questions? You're good, John? Yeah, Representative Slagle?
The question I would have is, it looks like these temporary water rights can be attained from any other person that already has a existing water right on this deal. So I would see it could be from a senior water right user or a junior water right user. So it kind of puts into question the whole deal, like Representative Krieger was talking about, taking out the whole deal of junior water right people not having that ability to shut stuff down when they call in as well. Because if it was another junior water right user that was having the temporary use, they would be on an semi-equal basis depending on the date of their water rights, if I'm correct in that. So I mean, that's where I would question how this is actually gonna work.
Mr. Chairman, Representative Slagle, I think that one thing to keep in mind is that once this agreement is entered, there are two water rights then. You have a senior water right that is supplying the temporary use, or you have the original. And I think in the situation that you're mentioning, it would be the entity that needs additional water would go out and find a water source that would even be junior to his. And so I think under that situation, the injury analysis would probably try to pinpoint which of those water rights would be the one that could be called. And I think it would probably be both. I don't know that we've seen necessarily this situation, but once those dates are set, that's what we're talking about, whether it's a senior right that can call it off or a junior right. I think the opportunity still exists, but it's less so that these agreements would injure somebody junior to the person that is providing the water. So I think that from that perspective is why that change was proposed. So like I said, the opportunity still exists for somebody to be injured, but it's less, typically less than. So I don't know if that helps answer your question, or if Chris heard something different.
Mr. Chairman, Representative Slagle, I'm not sure, I was fully tracking your question. I'm not sure I can add on to what the state engineer has said, except that, again, it matters not whether or not it's a junior or senior user on the front end when the injury analysis is occurring. The injury analysis is the same regardless of whether it's a senior or a junior right. I'd also point out that a provision of this statute, which is not included in the bill because it's not being changed, makes assumptions to leave all the return flows in the river. Okay, so the only portion of the water right that can be temporarily transferred is the historically consumptively used portion of that water right. So all of the return flows that would have otherwise been there, so let's assume in the vast majority of these cases, because they are the senior rights and the vast majority of rights in Wyoming, most of the rights that supply water to these temporary agreements are agricultural rights. And so that the intent of that portion of the statute is say, we're only going to allow you to transfer the portion that the plant consumes or that is otherwise consumed in the irrigation. We're going to leave the rest of the water, the return flows that would have made it back to the river, in the river. And in that way, junior users who came later are still going to find the river the way that they found it the day they came, because those return flows are still going to be in the river. And so that in and of itself addresses the potential injury to a degree for these temporary transfers.
Thank you.
Okay. Thank you. You'll be around. We'll have some folks and some scenarios that are concerning to people, and you'll be able to address those. So who all here wanted to testify? Okay. I think we'll start with Cindy and Cody McKee, if you'd come on up. And anybody you wanted to bring with you would be fine. Welcome to our committee.
Thank you, Mr. Chairman. And I also want to express my appreciation for the reordering and consideration today so that we could appear before you and testify. So good morning, Mr. Chairman and the entire committee. My name is Cindy McKee, and I'm here with my husband, Cody. We live in the Little Snake River Valley, east of Savory, where we own and operate a cattle ranch. You know, a recent article in Wyoming Industry magazine written by someone I respect encouraged producers in Wyoming to engage with legislature. The author made the point that while, of course, we should address the specific concerns regarding direct impacts on our ranch, our families, it's also, and I quote, equally important to engage with foresight on issues that, while not immediately impactful, may be crucial to the success of future generations on the ranch. It is exactly in this spirit with future generations in mind that I testify today about Senate File 65. It's easiest for this country girl to begin with what's at stake at our ranch. Our water rights consist of a modest original supply followed by a much more reliable supplemental supply, and that supplemental supply was so crucial that our predecessors engaged in the very difficult task of excavating the 13-mile Belvedere ditch. The Belvedere is the only source for irrigation and only source of stock water at our headquarters after our Miller Creek original runs out, which happens usually in early May. Our legal, historic diversion on Haggerty Creek for these beneficial uses correctly has never been regulated, even though the rights are junior to others downstream, because there's never been a substantiated shortage that required regulation and priority administration. We are living proof that Title 41 Wyoming water law has worked as intended. For our diversion to suddenly be regulated in any way whatsoever will necessarily deprive us of irrigated acres and impose a subsequent loss of land value. To experience a full shutdown would, put simply, be catastrophic to our family business. This is a threat that we are intimately acquainted with. There's no one in the state of Wyoming who knows our threat more than we do. And we understand about the motivation more than anyone, and we understand the threat to irrigators around the state that haven't even seen this coming. We originally thought that our time spent with you today was going to be about supporting the amendment that the Senate Ag Committee made. We were very, very concerned about the broadening of the temporary use statute to include the words beneficial use. Because of course, it's been discussed, so I won't belabor it. That gives water rights to fish, and the water rights would be, they would carry the same priority right as whoever changed the temporary use. Unlike permanent changes for in-stream flow, temporary would carry the priority of whoever changed the use. So we were super concerned with that, and we originally thought we were just going to be here supporting that amendment today. We see this word, this little word, beneficial use, in this bill, in the original intent of this bill, or the original text of this bill, this proposal. We see it as a ticking time bomb, because it would be there ready to be set off by a few other adjustments to Title 41 in the future. We know very well that this amendment is yet vulnerable to a midnight hour motion on the floor of the House. If it goes this way, we are asking you all on the floor of the House to defend this amendment. It's crucial. We also thought we'd be here advocating for a strike of the amendment in 111 regarding junior and senior water rights. I'll return to this in just a minute. But after lots of talks with people much wiser than us and with a lot of hard thinking, we realize that all we're doing is whacking moles. I want to cover just a couple basics that I want to return to basics on this and just ask us all to think with our common sense. Title 41 has traveled a lot of miles. It has worked well, and it must not be trifled with. Doing so will bring about unavoidable, profoundly negative consequences, either foreseen or unforeseen. First, there is no new water available. That's been established. Every drop has already been appropriated and is out being used on the lands. There is no additional to go get, no additional water to fill reservoirs. So the only way to change the way water's presently being used is to dry up acres, to take them out of production, to turn lands that are now flourishing into basically a desert. There's no way around it. As soon as we dry up acres, water leaves the state of Wyoming. We have a whole department, Wyoming Water Development, where we've invested millions of dollars trying to keep water in Wyoming. This is to the benefit of the lands and the communities in Wyoming. But as soon as we dry up irrigated acres, we are sending this precious resource on its way downstream and potentially impoverishing communities. Why would we do that? Further, there's no way to dry up acres and let water leave the state of Wyoming without interrupting historic use and incurring regulation. Historic use, always supported by Wyoming water law, is what my family depends upon to operate our ranch. Any disruption to historic use causes injury. There's simply no escaping it. And injury, I'm going to remind you, is absolute. One less bale of hay, one less gallon of water, one less acre of irrigated land is injury. The law says the state can't do that. And so there's all sorts of problems with Senate File 65. In its original form, it allowed for beneficial, temporary uses to be, for beneficial purposes, which opens the door for fish. And I acknowledge that this conflicts with other statute, which is why proponents said, well, this amendment isn't necessary because it conflicts with other statute. I hear that. But this is my exact point. We shouldn't be putting conflicts into Title 41. Any change of use can be renewed every 5 years. I understood it as into perpetuity, and maybe I misunderstood the language. I thought that even after 10 years, it could still be renewed with a renewed application. I'm probably wrong about that. But in its original intent, it was free to go into perpetuity. And this is at the total discretion of the state engineer, who is a political appointee. This is just the average person looking at this. This is a political appointee. It's a position that will be filled with a variety of people, with a variety of biases and influences. Senate File 65 in its original form clearly diminishes the rights of junior water rights holders. We listened carefully to the defense that proponents gave to this language, and it simply hasn't come out of the wash clean. We can't get past the black and white language that is in statute, where the original writers of Title 41 intended that a temporary use should be able to be challenged by a junior water rights holder equally with a senior water rights holder. That's what they intended. There's no way of getting around this is a diminishment. And I respect the state engineer's assertion that other places in statute, the language is there to articulate the process that he described. Okay, but we see this as a conflict with that. There's just no getting around that junior rights, the junior rights of your constituents are being diminished. And this is the first step of chipping away at the hard and fast rule against injury. And it is indeed our assertion today that Senate File 65 is an example of incrementalism, and here's what we mean by that. It's just one in a series of surgeries on Title 41, and because it's kind of flown under the radar, it wasn't called temporary in-stream flow. Irrigators in Wyoming haven't even had a chance to recognize and speak into this threat. If allowed to continue, these small surgeries can only end up in one place, creating a fog of conflicting statute and eventually making injury legal. This cannot happen. With the state engineer in a position of complete discretion over these decisions, and also the person to whom, the same person to whom the injured must appeal, I'm sorry, but that doesn't feel like an appeal to me, to appeal back to the same person who made the decision. So then we're leaving the injured appropriator's only real choice to sue. We must not set up a system in Wyoming water law that promotes litigation. And we certainly should not be putting that terrible burden upon its citizens. I ask this committee to protect irrigators in their district and across the state from incremental destruction of Title 41, statutes that have worked to protect Wyoming's farmers and ranchers for most of Wyoming's histories. Your constituents need a chance and deserve to understand the threat as Cody and I do, and to question this. Our young, hopeful future producers deserve their own chance to be fruitful, enjoy property rights, and pursue a life of their own making, rather than to be limited to working for others who end up winning what could soon be a political exercise of money and power. While it might be more politically expedient, I just refuse to stand before you today and ask you to do surgery on the surgery. I'm just going to ask for you to stop this, stop it today. There's too many open doors to trouble. There's too many risks. That's how we see it. And I'm just going to boldly say what I believe is right and true. We need to ask you to vote no today on Senate File 65. And we're open if you have any questions.
Committee questions? Okay, so the previous testimonies spoke of this bill as something that really doesn't change what's in existence. And somehow I'd like for this meeting that we have to resolve those differences if we can, because there are some benefits to this bill, or it wouldn't have been brought to you. And I guess something I'll take the liberty to say, anybody who's ever seen the Belvedere ditch and the way that thing works, it was over 100 years ago, wasn't it, that it was put in? Fairly primitive equipment, transits, and I don't know who the genius was who did it, but they'd drop water this way and laterally send it around the mountain, drop it another direction, and it ended up at the McKee Ranch as a source of irrigation that's very necessary to that ranch. I'm curious about a few things also that we may have either the state engineer or Mr. Brown come up, and because theirs isn't the only one affected. Another junior right on top of that mountain would be Cheyenne's Trans Basin Diversion. So could you just stay put, then one of you gentlemen could come up and explain, as you did before, why what we're doing will not harm or injure the McKees and their operation, if you would, please. Thank you.
Mr. Chair, again, Chris Brown with the Attorney General's office, and I'll do my best. And as long as I've had the pleasure of dealing with potential changes to Title 41, I fully appreciate the sentiment. You start messing with Title I and folks get very, very concerned because their water rights are dependent upon the structure and the certainty that doctrine provides, right? You've got the two basic tenets of the doctrine. Priority. Priority is king. First in time, first in right. And then beneficial use. That is the other basic tenet of the doctrine of appropriation. Beneficial use is the basis, the measure, and the limit of a water right. And that's built into Wyoming's Constitution. So I would submit to you that the idea that this statute simply reflects beneficial use is just a repetition and recognition of the doctrine that's been in this state since before 1890. So I don't think adding beneficial use to this statute does anything but reflect Wyoming water law as it's always existed. To the injury question, this is also something that has existed in Wyoming water law since territorial days. If you're going to make any change to an existing water right, and if you look over the history since 1870 to now, there's been different opportunities. There's been a recognition by the legislature that things change and there needs to be some reflection of that in how we deal with the ability to change existing rights. And so you'll see an evolution with regard to the potential ability to change, where there was an absolute ability to change prior to about 1909. Then there became a greater restriction on the ability to change between then and about 1965, and then a recognition again that some changes needed to be allowed in order to provide for beneficial uses in the state of Wyoming, okay? Every single instance from the very beginning until now, if you're gonna talk about a change, injury has to be considered. The change cannot be made if it's going to injure another appropriator. This bill does not change that and cannot change that, in my opinion. And the language of the bill does not change what's in the existing statute, which requires the state engineer make an analysis about whether or not it will injure another appropriator. That is true for any change to a permit. That's true for any temporary change, any exchange, any permanent change that's brought before the Board of Control. That is the constant that runs throughout those. There might be some other conditions and requirements for those different tools and mechanisms, but the absolute constant with regard to all of them is no injury. And this bill does not change that.
Committee? Representative Davis?
Mr. Chairman, well, we have you here, Chris. Could you explain the difference, or clear up the difference for me, between historical use and appropriated water right? What are the two differences there?
Mr. Chairman, Representative Davis, so beneficial use generally has two components to it, right? It's the purpose, right? It's typically what we think of, there's 5 main beneficial uses in Wyoming: irrigation, municipal, industry, the purpose that you're looking at. What is the purpose for which it's being placed? And so there's a list of identified and approved beneficial uses in Wyoming, okay? The other element of beneficial use is this idea of the basis, the measure, and the limit of the right, which means just generally that you can only use as much water as you need to satisfy that purpose. You can't use any more, because if you use any more, that's waste. We don't allow for wasteful use. So that's the second component of it. But as far as the amount of water that you need to have to achieve the purpose is really dictated by the circumstances of the particular case. Is my ditch 13 miles long? Is my ditch 1 mile long? How much water do I get put in the head gate to get to my field, right? You have conveyance losses depending on your soil. You might have a lot of ditch losses that come back to the river sooner. I mean, it just really wholly depends on the facts and circumstances of the individual case. Now, for irrigation uses, we have a water duty in Wyoming as well. So you can't just take whatever you want at the head gate. We have a 1/70 water duty that then, of course, is informed if your water right is pre-1945 or pre-1985. You can put a second in your ditch. So you have that water duty, but you can put in that much water even if your plant doesn't need that much water to grow it. And so the difference between the full beneficial use is how much do you need to achieve that purpose without waste? And then the consumptive portion is whatever it's necessary to achieve the use at the end point of use. And if we're talking about irrigation, it's generally consumption, evapotranspiration. And then the other incidental consumption that goes along with it. I'm gonna lose some of that water, deep percolation, or if it's gonna go down a drain that's got a lot of phreatophytes or something. So there's a difference between how much you can take at your head gate and how much you're ultimately gonna use to achieve that purpose. And what the temporary water use agreement statute does is it makes a simplifying assumption with regard to irrigation, because these get approved fairly quickly because they're temporary in nature, they're not permanent. It says 50%. We're gonna assume 50% of that water was coming back to the stream. And so we're only going to allow, if it's an irrigated right that's being temporarily transferred, we're only gonna allow 50% of that to be transferred. If you were gonna do a permanent change in front of the Board of Control, they are not gonna make a simplified assumption. They're gonna ask for a whole lot more information, a historic consumptive use analysis with regard to what was actually consumptively used, so that they can make a better determination about whether or not that permanent transfer is gonna injure some other right, whether that right's junior or senior. So just generally, conceptually, one is how much do you need to put in the ditch to get your work done, and how much is actually consumed for the beneficial purpose. The same analysis can go for municipalities. They're gonna have some return flow, some effluent, potentially.
Committee, any other questions? Representative Slagle?
Yeah, one question I would have, I mean, you said we have a list of beneficial uses. So my question would be, has that list changed in the recent past or over the years, or what's kind of been the history of our list of beneficial uses?
So, Mr. Chairman and Representative Slagle, you can find, and I think probably, and I haven't asked this specific question, but since statehood, the big categories, right? And so the big categories are irrigation, municipal, industrial, stock, domestic, and then you have this catch-all miscellaneous. okay? And most of those recognized beneficial uses have been around for an extremely long time. Some of them are antiquated, uses that you would think of back in days before electricity that perhaps we don't engage in any longer. But the Wyoming Supreme Court and states throughout the West that recognize the doctrine of appropriation also recognize that the idea of beneficial use is an evolving concept that meets societal needs. And so the last major change, to my knowledge, at least in Wyoming, to recognize beneficial uses was the product of this legislature in 1986, when it recognized in-stream flows as a beneficial use. But as part of that recognition, it also recognized that only the state of Wyoming could hold an in-stream flow water right. And the Attorney General opinion I mentioned from 2015 relied on that very heavily when the conclusion was reached that you cannot use this temporary water use agreement statute to supply in-stream flows because only the state of Wyoming could hold an in-stream flow. Also, it found in-stream flows aren't a temporary purpose. Fish don't need water temporarily, and therefore this statute doesn't work for in-stream flows because in-stream flow is not a temporary purpose.
Okay, committee? So I guess a question I would have for you, Mr. Brown, the beneficial use for the city of Cheyenne and the water that is transferred from the top of the mountain to this side of the mountain it's a different beneficial use. Does that affect injury, the way you judge injury or any of that? Is it different?
Mr. Chairman, without noodling on that longer, I don't think it matters at all. I mean, if it's for a temporary beneficial purpose, the injury analysis is exactly the same. And so if you're trying to move a water right from where it's appurtenant to a temporary purpose, we do the injury analysis regardless of where the water right's coming from and to what purpose it's going to be used. No matter what that is, you need to make sure it's not going to injure any other existing appropriator. So I'm not sure I was tracking your question completely, but I don't think it matters what the ultimate beneficial purpose is.
You've assured me that it's the same, which is what I needed to know. Committee, any other questions? Well, the three of you are up here. So my understanding is what we're doing with this new bill is just changing language and essentially you can do the same thing whether we pass this bill or not. Am I correct on that?
Mr. Chairman, yes, with two differences. The existing statute says 2 years, the new one says 5. The existing statute has no cap, the existing statute has a 10-year cap. The existing statute doesn't differentiate between the juniors and seniors as far as responding to a call for regulation. The amendment does differentiate between senior rights and junior rights. Doesn't mean a junior right can't make a call. It just changes the way the call is responded to as between juniors and seniors. Otherwise, Mr. Chairman, you're absolutely right. The initial motivation behind these changes was try to supply a little bit of additional certainty to those junior users who might engage in this tool. So the primary thing I think they were seeking was the 5 years, because they felt that that would offer them a little bit more certainty entering into arrangements with senior appropriators if they had the opportunity to do a 5-year agreement as opposed to a 2-year agreement where they couldn't be assured that the state engineer would renew it after 2 years.
Mr. Chairman, may I ask one question?
Yes, go ahead, Mrs. McKee.
There we go. I just have one question that I thought of as during this discussion. Thank you, Mr. Gebhardt. My question's for you, or Mr. Brown, excuse me. My question's for the State Engineer's Office. I would like to know if, in an injury analysis, if a condition of regulation will be imposed, is that where it's never been imposed before, will that be considered injury?
Mr. Chairman, I'm not sure I'm tracking that question. I think, this was part of the discussion as we were on the work group with trying to put together this language. And one thing that we try to be extremely careful of as we're considering any changes to Title 41, the one certainty that I absolutely know is that I'm never going to be able to conjure every factual pattern that might pop up throughout this state into the future. And so trying to answer something in absolutes is very, very difficult until you get the specific facts and circumstances of that particular case in front of those that are charged with enforcing the statutes. And so I believe in the orders that approve these temporary water use agreements. And the same is true with regard to exchanges, for example. There is still authority left to and explicitly identified for the water commissioner to say, if something comes up, you have the duty to investigate, to ensure that what is being done under this order, under this exchange, under this temporary water use agreement is not injuring other appropriators. And so that's left to the folks who are charged to regulate the water to make that determination, because a whole lot of facts can inform whether or not that's true.
So a question I would have, if there is disagreement between the water commissioner, regulator, and a irrigator, or whoever has an adjudication, does the state engineer's office intervene at all, or is this a judgment made at that level?
Mr. Chairman, as I mentioned, there's a process set up in the statutes, and it applies to this circumstance just like it would in any typical regulation circumstance, where any appropriator, any water right holder believes that their water right is not being satisfied, can request that the stream be regulated to satisfy their right. It's the water commissioner's duty under statute to go investigate and regulate in order of priority, to make sure that the water rights that are entitled to the water are in fact receiving the water. And that would be the same analysis with regard to the employment of a temporary water use agreement. Are they being injured by this change that was affected by this potential agreement? And then the statutory process, as I mentioned, goes from if the appropriator, the irrigator, doesn't agree with the water commissioner's conclusion, it gets appealed to the superintendent. And if the water user doesn't agree with the superintendent, it gets appealed to the state engineer. And if they don't agree with the state engineer, there's appeal to the district court. And the reason that it goes up that quickly is, number one, since territorial days, our Constitution has recognized that water regulators are much better equipped, professionals with experience in water use and water regulation, much better equipped than our courts to try to figure out these questions on the front end, because the state engineer's policy is to address these in intervals of 2 days so that it can happen very, very quickly. Sometimes it's too complex and it takes a little bit longer, but to make it happen very, very quickly, but allow it to go through that process in that quick manner before folks are then forced to go to the courts to resolve the dispute.
Okay. Are we good? No. Representative Winter.
Yes, thank you, Mr. Chairman. Mr. Brown, my question, I guess, relates back to the fact that so much of the text has been removed with this bill. And are we sure that we're not going to regret that, and that we're taking out railroads and transportation entity here? Couldn't that again come up someday that would be pertinent to our current situation?
Mr. Chairman and Representative Winters, I'm certain I can't opine on whether we'll regret it. I don't think so. And the reason I don't think so is just examining the history of the statute, how it came to be and how it's evolved, is an effort generally, in my view, to make provision for these temporary purposes. And it's always been that way. It's tried to, because a criticism that has occurred over the history of the state and the West of the doctrine of appropriation is too rigid. It's not flexible enough. It doesn't allow you to move things, and therefore you can't make accommodation for new uses. And if you look at the history of this statute, its purpose was to try and satisfy, provide water to these temporary purposes. And that has been since the last time it was amended, and I'm sorry, I didn't go back and double check when that was. The temporary purpose limitation has been the catch-all limitation. It's been there. It's in the statute. And so all this does now is just say it's for temporary purposes instead of giving you 3 examples of temporary purposes and then saying other temporary purposes. Now it just says temporary purposes.
Okay. Well, thank you. McKees, did you have any other questions you wanted to? Okay, or for the state engineer?
My husband's question, and it's just a little more specific version of the question I asked. Yeah, why don't you ask it?
Mr. Chairman, I think this is probably a question for Mr. Brown, and I haven't looked at the hydrographer commissioner handbook. I just saw this up here. As far as it goes, if someone applied for a temporary use, could any appropriator like us be held to a single while the rest of the drainage perhaps is even under Free River administration? And would a single be considered an injury?
Wow. Mr. Chairman, I'd probably have to think about that quite a bit more. My immediate reaction is that your single and your double are both water rights recognized under Wyoming law. And so the assessment requires the state engineer to investigate whether or not the proposed transfer will injure other Wyoming water rights. So both by virtue of the surplus water statute, which gives every appropriator that had an irrigation right prior to March 1st, 1945, an additional CFS, that the Wyoming Supreme Court has recognized is its own water right. And so the analysis that the state engineer would have to engage in is whether or not there's injury to other water rights. That being a water right, I would conclude, sitting here without digging into it further, that injury analysis would have to include those rights.
Okay. Thank you. I think we'll move on. Thank you, everybody, for your testimony. Mr. Berger, you want to come on up?
Thank you, Mr. Chairman, members of the committee. I'm Jack Berger from Saratoga, rancher and water right holder, so this concerns me. We tried over in the Senate to work on this, and we got the critical language in there about the in-stream flow, which, seemed to help, because that's definitely a concern which leads to regulation. I hope you all understand regulation and what that does to us. Last week, had a water attorney look at this. He hadn't previously seen it, and he really had concerns with it. He thought the beneficial purposes just seemed way too broad the way that is now. It just seems open-ended. We talk about beneficial uses here. This is beneficial purposes. My son Kyle, I know Senator Hicks had a lot to do with this, and he asked him like 3 weeks ago to explain beneficial purposes. There was never any response. So that's sure a concern. The language being changed in there to not protect juniors, I mean, that's a big deal right there. And that's another thing that can lead to regulation, and it diminishes the junior rights. And I think you just heard here that they'll try and get there in 2 days to address a junior. They say they won't automatically shut off the the transfer, they'll look into it, hopefully be there in 2 days. And then, did you hear the explanation of the process after the 2 days? That's a long time. And I think diminishing our junior water rights like that with that language change in there sure hurts us. You know, I was involved in the Pathfinder modification project quite a few years ago, and, you know, sending water to Nebraska for endangered species, and we all know it didn't work. We sent the water and the water's not being used and the way it was intended and stuff, and there was mistakes made there. But during our negotiations on that, John Lawson was the head of Bureau of Rec at that time. And he said, "Don't worry about me. I'm not a threat unless there is regulation." That's what we need to think about on this regulation. We just let the feds get their nose under the corner of the tent on this deal. If we, any of these things that changes Title 41 that would push us towards regulation. So, I don't know. At this point, I don't know what we can do with this bill. I think there's too many problems there. You know, we got our protection supposedly for in-stream flow, but, you know, especially the juniors and then the beneficial purposes and stuff that's just, I feel is just way too open-ended. So, I guess I would urge your no vote on this at this point. So.
Committee. Thank you.
Okay, thank you.
Other people that would like to testify on this?
Hi, Mr. Chairman, members of the committee. My name is Catherine Stahl. I'm with Powder River Basin Resource Council. Last night, we sent over a proposed amendment to this bill, which we think could strengthen it. It establishes a public reporting requirement for any temporary water use agreements as approved under this section. I'd be happy to read the amendment. It's one sentence. You should have it in front of you, but okay. So the amendment reads on page 3, line 2, after years, insert, not later than November 1st of each year, the state engineer shall report to the Joint Agriculture, State, and Public Lands and Water Resources Interim Committee on the volume of water that is acquired and put to beneficial use through temporary water use agreements approved under this section. And we do believe that this would strengthen the bill and help improve public transparency for any water use under this section. And I will stand for any questions.
Questions, committee? Okay, thank you.
Thank you.
Any other testimony? So, yes. Mr. Obermuller, welcome to the committee.
Good morning, Mr. Chairman, members of the committee, Pete Obermuller, Petroleum Association of Wyoming. Mr. Chairman, I don't remember testifying in front of this committee for a very long time. So for that reason, let me just very quickly say the Petroleum Association represents around 175 companies and individuals that on the entire spectrum of oil and gas production in Wyoming, from explorers to producers to pipelines, midstream pipeline transportation to downstream refining, and everything in between, wildlife biologists, petroleum engineers, et cetera, in the whole scope of oil and gas production in Wyoming. Thanks for that introduction, Mr. Chairman. So let me just be real clear with the committee. Petroleum Association did not bring this bill to Select Water. In fact, we did not participate in the interim discussions on it. Just sort of watched it for interest. Obviously, industrial use is important to many of my members. We were neutral on the bill as it was introduced. The engrossed version, unfortunately, turns us to oppose to the bill as stands. I have an amendment suggestion that would bring us back to neutral, two different options if the committee were so inclined. The issue in the standing committee amendment on the Senate side that gives us heartburn is on page 3, lines 1 and 2. It's the total length of any transfer, including extensions thereof, shall not exceed 10 years. So, Mr. Chairman, I understand that the temporary water use is supposed to be temporary. That's the idea, and the effort there was to try to sort of enforce temporary use. But, Mr. Chairman, the trouble with that for us is that it, as you've heard discussed, there is really no way to anticipate what might be necessary in the future in terms of a temporary use. So that language shuts it off at 10 years and allows no other option after that fact, is the way we read it. So POW would move back to neutral on it, doing one of two things. One, on page line 1, starting with the, strike the rest of that sentence and to 2. So that would leave it at, you have the 5-year increments and the all of the scrutiny that you've heard talked about over the past half hour or so. An alternative to that, Mr. Chairman, would be leave the sentence, but on line 2, after the number 10, insert the word consecutive. And that would also alleviate our concerns. Again, to be totally honest, what that would do is move us back to neutral. We're fine with status quo, and we're fine with this bill under that scenario.
Committee, questions? So temporary use of water is used frequently in the mineral industry. With or without the bill, the mineral industry would be able to continue to perform the way it does. Am I correct on that?
Mr. Chairman, I believe so.
All right. And you have some amendments you think would improve the bill. So we will consider those. No questions? Thank you.
Thank you, Mr. Chairman.
Did we have other testimony? Yes, come on up, Holly.
Good morning, Mr. Chairman, members of the committee. Holly Kennedy here today representing Wyoming Association of Conservation Districts. And I'm also joined online by one of my board members, Chris Williams, who will also be providing testimony at the same time, if that's okay. Okay.
Go ahead.
Great. So I will just kind of kick off some of our key concerns here and then turn it over to Mr. Williams and then provide a little additional information if that's okay with you. Okay. While we appreciate the attempt to put some parameters around this current statute and to try to further define what temporary water uses may look like, we do feel that perhaps this bill is a little bit missing the mark at this point. And I think, as you've heard from a lot of the testimony today, that perhaps there's still some unknowns out there. I do appreciate the state engineer and the state attorney's testimony on this. And it's always great to vet out those black and white parameters of the law and of how you see things happening based on the law and based on what's written. But we here in agriculture and natural resources know how quickly things turn from black and white to gray and how quickly we can be affected by the gray. And my fear with these changes is that we're leaving too much out there to become gray. We are very concerned about the way this can affect and change and make changes to the landscape and to natural resources. Because while the state seems very certain that this is not going to make drastic changes to return flows, we are less confident in that. If you take a land in production that has a forage crop on it, and you remove water and you remove the shade that forage crop provides, you're making a drastic change to that landscape. You're doing that if you're doing it for 2 years, and you're especially doing that if you're doing it for 5 years. and now we're talking 10 and possibly more than 10. I would question at what point is temporary. And I understand the certainty that industry would like to have, and I understand how this affects their business model being confined. But I would counter with, what are the impacts to the users? What are the impacts to the landscape from a change in use? 2 years in a drought scenario can be a long time for a landscape to go without water. And we all know how consequential that can be. So I'll leave you with that thought and turn it over to Chris, if that's okay for a moment, and then I'll come in with some conclusory remarks on behalf of Wyoming Association of Conservation Districts.
Good morning. Can you hear me?
Yes, go ahead when you're ready.
Yeah, good morning. I'm Chris Williams. I'm from over here at Saratoga, and I'm an irrigator, and I'm on the WACD board. My thoughts have pretty well been covered. A few things that I'd just like to reiterate is I feel like the bill without the amendments provided a little framework and intent, and I don't like the ambiguous nature of the temporary beneficial purposes. I feel like that leaves a lot up to the imagination. And I know that I know purposes and needs change, but I feel like in this situation, gridlock is good. I don't feel like it should be easy or easier to get the water and use it for beneficial purposes. I know that it can be. I know it has there's a procedure in place, and I'm not in favor of it being any easier. I like the gridlock. I feel that's as an irrigator, that's my protection. And when Wyoming water law isn't flexible, I take comfort in that. I think that's what sets Wyoming apart, is those protections. And I like it to be difficult. I feel like these temporary uses should be scrutinized, and I don't feel like it should be easy. And in over here where I am, I'm on a stream that doesn't have real reliable flows year to year. One year we're great, the next year we're not great. And anything that makes regulation or causes regulation is a nightmare to me as an irrigator, because I'm less efficient when I have to wait on the state to regulate my ditches. And that's not a knock on the state. It's just on that type of year, they're super busy, and their response time is limited to a very large area, which they would require regulation. And so anything that brings about more regulation, or in my mind could cause more regulation, causes me concern. And that's about the extent of my comments.
Questions, committee? Okay, thank you, sir.
Thank you, Chairman Eklund. So in conclusion, on behalf of the Association of Conservation Districts, I think we would pose the question of if we have enough facts in front of us at this time, and would certainly pose that perhaps some more discussions could really improve this and really provide a lot of the certainty that I think you're hearing the request from the room for. In the spirit of attempting to make this more black and white, should you choose to move forward with it, we do have a couple of specific points of feedback that we would provide. One is we, as we testified in the Senate committee, we would prefer to see this stay at 2 years rather than the increase to 5 years. I think we are amenable to the 10-year cap, but I think 2-year increments is a lot more temporary in nature than 5-year increments. We also have very big concerns about any potential end arounds towards in-stream flow and the use of temporary waters for in-stream flow. And one point of consideration is perhaps a prescriptive list is a way to go to make sure that we aren't opening this broadly up to a wide variety of uses, perhaps defining what uses can be considered for these temporary uses might be helpful in strengthening this bill and providing us all with a little bit of certainty. And then I would also draw to your attention on line 17, the language there speaks to the approval process. And I would just question if maybe there's another word we could use there that speaks to both the consideration prior to allowing the issuance and afterwards, should anyone say that they are harmed by this. So perhaps another word such as allow or something along those lines instead of approve might strengthen the bill a little bit there.
You lost me there. Are you on page 2, line 17?
Yes.
Okay. Okay, go ahead and repeat what you just
So on
shared with us.
page 2, line 17, it says the state engineer shall not approve a temporary transfer if it injuriously affects the rights of other appropriators. And I would say allow or something along those lines may speak to the facts both prior to approving that use and afterwards, just to ensure continuity that if someone is injured at any time during that transfer, that there is that strong statement there that will not be allowed.
Okay. Our lines are different, I believe.
Oh,
So,
okay.
okay.
Apologies for that.
All righty. Questions, committee? Thank you.
Thank you, Chairman Eklund, members of the committee.
Mr. Moline.
Mr. Chairman, Committee, Brett Moline, Wyoming Farm Bureau Federation. Part of my policy is on water rights is that before anything is done, the other users should be notified. That in other instances, I know that's not common practice, is what happened to one of my members where a livestock in-stream flow was put on. The other users weren't notified. What I think I know my policy would really support on this is that before a temporary use would be granted, the other users on the affected stream would have to be notified. I think that would put everybody on the same page that this is what is potentially going to be a temporary change. And it would facilitate the other users, should they be affected, to have that feedback before the temporary change occurs, which would put them on a more level playing field. So I would ask that as an amendment. I don't know where that should go, Mr. Chairman. But I think having the other users notified before the change occurs would be important, just so everybody's on the same page. With that, Mr. Chairman, I would sit for any questions you or the committee may have for me.
Questions, committee? Thank you, sir. Was there any other testimony? Mr. Brown and Mr. Gephardt, would you come on up again? We'll ask you a few questions about these possible changes and how they would affect the bill. There were several of them, and I think there might be more, more change than what you proposed to us in the first place. One of them was reporting back to the Ag Committee. I don't know if you were able to track that possibility.
Mr. Chairman, I think what I heard is to report the water use back to the Ag Committee that's under these temporary agreements. And I'd have to confer with my staff to see what that would mean to them. Maybe a suggestion that the report would be any new temporary water use agreements that were approved in that given year. I think we track those somewhat, but I need to talk to my staff to see what kind of issue that may cause. Basically what I'm saying is I don't have an answer for you today.
Okay, all right. Yes, Representative Slagle.
Yeah, I think looking at that amendment that was proposed, I think it wasn't only reporting of the temporary permits, but it was also reporting the water that was acquired and put to beneficial use. So that, I mean, that kind of changes the requirements of the report, I believe.
Mr. Chairman, after reading that, I would like to confer with my staff before I answer that.
Sure, and if the bill continues, we can amend it later if necessary. Quick question, is there any difference between beneficial purpose and beneficial use?
So, Mr. Chairman, I attempted to try to answer that earlier, and it's sometimes a difficult thing to wrap your head around, but beneficial use under Wyoming law has two basic components, right? One is the purpose. It's the irrigation, it's the municipal, it's the industrial. What is the purpose that the water is being placed to? And it's also the amount. That's also beneficial use. Beneficial use is the basis, the measure, and the limit of the right. How much water is necessary to satisfy the purpose without waste. And so this statute, and I'll point out that the existing language also says temporary purpose, is focused on the type of use, not the amount, but the type of use has to be a temporary purpose.
Okay. Thank you. There were some other suggested possibilities in committee. You can help me whenever. Possibility of 2-year increment and which would be a little variant from the 5 years. What are your thoughts on that? Does it significantly change how policy would be from your perspective?
Mr. Chairman, I don't know that I have a thought on that. I believe that is probably for this body to decide what they want it to be. In practice, I don't know. To our agency, we were fine either way, 2 years or 5 years.
All right. I believe there was another one. There was I think, the oil industry would like to change the part 10 consecutive years. Does that cause any heartburn for you? That would be, could be done 2 ways. I was on page 3, line 1 and 2. Either eliminate it altogether and stick with 5-year increments, or leave the total length of any transfer, including extensions thereof, shall not exceed 10 consecutive years. We would just insert that word.
Mr. Chairman, I don't know that I have an opinion either way. One of the things that we always analyze in the applications is that temporary purpose. If it's not temporary, then it needs to be something of a more permanent change, which there are methods to change water rights permanently. But we do that analysis on every temporary application we get.
Okay. So you probably have a prescriptive list of temporary uses already, am I Did those ever change?
So, Mr. Chairman, to my knowledge, the state engineer's office has not tried to come up with an exhaustive list of temporary purposes. There is a published list of recognized beneficial uses. And I would suggest that, like most things, the state engineer waits until he has specific facts in front of him at a particular time to make a decision about whether or not whatever's being applied for satisfies that temporary purpose requirement. And I want to identify something that I think that I think informs somewhat the desire or the intent of some of the industrial users, primarily in our Green River Basin. And so this temporary water use agreement tool is one that's been used successfully for quite some time with regard to providing junior municipal users in the North Platte. The temporary purpose identified in those instances is when you have an allocation under the North Platte decree, so this is not for the endangered fish downstream, but our obligation under the 2001 modified decree to the state of Nebraska and to the Bureau of Reclamation with regard to the federal reservoirs on the North Platte. The temporary purpose is to allow these municipalities to engage in this tool to replace that water that gets turned off because they are junior to those federal reservoirs. Okay, so the temporary purpose in that particular factual scenario is induced by our downstream interstate obligations. And in the Green River Basin, where these questions have come up, that is the same consideration as we see the water supply diminish, drought continue in the Colorado River Basin, the chances of potential curtailment to satisfy our obligations under those compacts could result in temporary reductions in our junior users, our post-compact users, which by far and away are municipal and industrial users in that basin. And so the temporary purpose is the result of the need to curtail those uses to satisfy our downstream interstate obligations. And so coming up with or excluding specific uses like municipal wouldn't then allow this statute to satisfy those temporary purposes that are brought about by that interstate obligation. That's my caution about trying to come up with a list.
Okay.
Because it depends on the facts of the particular case.
Well, I think we'll not even try to do that. Committee, any questions? Further questions? Yes, Brandon.
Chairman Eklund, thank you. And one comment that I heard that I didn't do a very good job explaining as to why this came about. Part of the concern that we heard from some of the junior water users, specifically in the Green River, during some of our committee meetings, Colorado River committee meetings, and some of the other public meetings we've heard over there, is they want a certain temporary exchange or use type of arrangement. Because one thing that we've heard over and over again is we do not want buy and dry. The state does not want buy and dry. I think the comments that I've heard recognize that. And so they're looking for these somewhat temporary tools so that they don't have to engage in a buy and dry situation. So that was some of the desire to create more certainty with these temporary mechanisms from some of the people that we've heard from.
And some of those were junior rights holders.
Yes,
Okay.
absolutely.
And one comment that was made was a concern that this would damage the junior rights holder, which came from testimony in the public, which is just the opposite of yours. Your testimony was that this would strengthen the junior rights holders' right in this. Am I correct on that?
Mr. Chairman, I think my testimony was that the amendments to this bill make no changes to the injury analysis that's performed under the existing statute. The existing statute requires injury be assessed, and it will continue that way under the changes.
Okay. Representative Craigo.
Yeah, I think we're all confused about this a little bit, and I think we ought to try to clear it up before we vote on this, because I think it's important. I mean, I'm still focused on the stuff on page 3. And you talk about an injury analysis. And so as the language currently sets in our statute before this bill, if a junior, and let's just do a scenario, okay? We have Ranch A, Ranch B. Ranch A has a 1900 water right, Ranch B has a 1910 water right. Let's just do it that way. So senior, junior. Ranch A transfers their water to a industrial use. If Ranch B is not getting their water following the transfer, what happens?
Mr. Chairman, if Ranch B is junior, then he would provide a written complaint to the hydrographer. At that point, they would go out and investigate to see that if it was a valid call or complaint at that time. If it is a valid complaint, then they would do priority administration to satisfy that claim. So it would be just like whether there was a temporary use agreement in place or not, that would still occur. So that wouldn't change the way a call would be handled. The thing that this changes is right now, if that junior, without these changes, if that junior were to make a call, then the temporary water use agreement is shut off, and then the investigation occurs. With the changes to the senior, it only changes the timing of that. Does that help answer your question?
It does.
Right. I think. Thank you. So we'll close testimony. I don't see anyone else. Oh, did we have someone online? Not for this one, okay. Committee, what's your pleasure?
Move the bill.
Been moved by Davis, seconded by Banks. Committee discussion. I guess a couple things I'd like to say is I think, we're all aware that any changes to water law affect those rights holders, all of them, senior, junior, everybody. And so we have to be really cautious about doing it. And this was brought to us as a tool, I think, to improve how we administer water rights, especially in these temporary use agreements. They're already done. This would maybe expedite that tool, is my understanding. And I'd kind of like to see the bill go forward and see if we can do any language that would repair it and settle in people's minds why we're doing it, rather than have to wait a couple years from now and just do it again. Because that's what'll happen. We'll just keep seeing it over and over again. And I prefer fixing things while we can, and we're in a position to do that, so go ahead.
Thank you, Mr. Chairman. I'm going to be a no. And I guess part of it is I just don't read that provision the same way our good state engineer does, or his lawyer from the Attorney General's office. If you read down on lines 14 through 18, it says once you've made that call, the temporary diversion is shut off until such time as that owner's right is satisfied or until it's proven that it's not affecting their right. I mean, that's what the language says. And I personally think that overrides other sections of the statutes in Title 41, because the specific in statute always overrides the general. And so it's my opinion that we are affecting junior water rights by changing that language. And so I'm going to be a no until I can be proven wrong, which happens all the time, so I probably will be. But today I'm a no, because I think we're going to do more damage than good to our agricultural producers.
Okay. Other discussion, Representative Winter.
Yes, thank you, Mr. Chairman. It seems to me that things have been working pretty good for quite a while, and there's so many questions on this bill right now that I think I'm pretty sure I'm going to be a no vote as well. I think we need to put it aside and see how things, if there are some verifiable needs here, and then work from there. So thank you.
Representative Davis?
Mr. Chairman, I'm gonna probably be a yes on this because I think this takes some of the gray area and discretionary out of the state the state engineer's office and gives them direction on how they do attempt this and work with this.
Further discussion? Okay, so Representative Craigo, the parts that you brought out that were of concern are existing language. Can you see any way of altering that so that your concerns would be settled somewhat? And I'm not just sure how it changes, since it is existing language, I'm trying to figure out how this legislation. Go ahead.
Thank you, Mr. Chairman. I suppose we could just cut that part out of the bill. I mean, you could cut out lines 3 through 19 on page 3.
Okay. That would be a significant change. Okay. Any other discussion? So my concern remains the same. If we don't deal with this today and try to get it fixed, we can move it to the floor and we can add amendments to it until people are satisfied. It'll just keep coming up, and I would rather get things settled now so that these water users don't have to be concerned with what's going to happen in the future. I think that if it doesn't pass, we're able to function pretty much as we could before. So was there any more discussion? I think we're ready to vote. We're not gonna amend anything, not just now, I guess.
Representative Alderman, no. Representative Allred,
No.
Representative Banks, aye. Representative Craigo,
No.
Representative Davis,
Aye.
Representative Slagle,
No.
Representative Winter,
No.
Chairman Eklund,
Aye.
3 aye, 6 no.
Okay. So the bill as it is fails, and we'll probably work on it next year again, is my guess. Well, thank you. I don't think we have enough time to do justice to the other two bills. They'd be fast, but we've got to get up. We're going to gavel in shortly. Thank you, everybody. This meeting's adjourned.